For most people, mental health help could look like engaging with health services, taking regular medication, or reaching out to support networks, to name a few. But what happens when someone is too unwell to decide their own mental health treatment? In some cases, a legal order called a mental health order may step in, which will require someone to receive involuntary treatment. It can be really scary and confusing for the person under a mental health order, especially if they don't understand how and why the order was made in the first place. In the ACT, mental health orders can be made by the ACT Civil and Administrative Tribunal under the Mental Health Act. There are a number of mental health orders that the tribunal can make, but for the purposes of this video, we'll be focusing on Psychiatric Treatment Orders, also known as PTOs.
I'm Associate Professor Anthony Cidoni. I'm the Chief Psychiatrist of the ACT, and it's my responsibility to administer the Mental Health Act in the ACT. Psychiatric treatment orders require a person with a mental illness to receive treatment, even if they do not have decision-making capacity, or are unable or do not consent to the treatment. Without treatment, they may be at serious risk of harm or deterioration. Medical staff will only apply for PTO if we believe it's necessary and appropriate, and there's no less restrictive way to manage a person.
That might sound confronting, because it is. However, there are legal checks and balances to make sure that a decision to make a PTO has been made lawfully.
The law sets a very high threshold for when a psychiatric treatment order can be made. A PTO can only be granted if the person has a mental illness, they don't have capacity to consent to treatment, care or support, or they refuse that treatment, care or support. There are reasonable grounds to think the person might cause harm to themselves or others without treatment, care or support, or suffer a physical or mental deterioration as a result of their mental illness. Treatment, care or support is likely to help the person, and there's no less restrictive option available for that treatment, care or support. If all those conditions are satisfied, the tribunal can only make an order for a maximum of 6 months. After that, it gets reviewed, and only if all those conditions are met again at a fresh hearing can another order be made, and people are entitled to be represented at each of those hearings.
So what actually happened at a hearing for a PTO application? Well, even though it's called a hearing, it's much less formal than court. At the hearing, you'll have your decision makers, the treating medical team, the person subject to the PTO application, and their lawyers if represented.
My name is Magistrate Robinson. I used to be a Presidential Member of the Tribunal and to make decisions about mental health orders. The Tribunal is not the hospital, and we're not part of the treating team. We're an independent body, and our role is to apply a legal test to determine whether a person requires a treatment order. We do this not by forming a medical opinion, but by looking at their circumstances and their medical background and determining whether the legal test applies. We do this through conducting hearings in an informal setting. We hear from the person who might be subject to the order, from anyone else who they would like to speak at the hearing, including their representative, and also from the treating team. We consider all the information available, including the person's personal circumstances and their medical history. Together, this helps us to understand what supports are available to the person, whether they require treatment, care and support, and whether that can be provided in a less restrictive way.
And throughout this hearing, the person under the PTO application is not alone.
My name's Geordie. I'm a human rights lawyer with legal aid, and I represent people at PTO hearings. I can assist them if they're in the hospital or in the community. My job is to protect their rights and make sure the tribunal applies the law correctly. I do this by firstly conferencing the person to figure out what their views are. I analyse the medical material that's available. At the hearing, I'll cross-examine the doctors and make submissions to the tribunal on behalf of my client. People can speak for themselves at a PTO hearing, but they also don't have to. Now, if you have a loved one before the tribunal, or if you are subject to a PTO yourself, you should know that PTOs can be reviewed. Even if you're already subject to one, you can seek a review of that decision, and legal aid can help you with that.
If you have a loved one under a PTO, you can play a role in their recovery and support in this time.
We encourage friends and family to be part of those supports. your participation can make a real difference. For example, you can be in contact with the treating team if your loved one agrees to this, to help build trust. You can attend the hearing, again, if your loved one agrees to this, and provide them support. Or you can provide practical assistance, for example, helping them to attend medical appointments.
Psychiatric treatment orders and other mental health orders ultimately exist to promote the recovery, safety, well-being and support of people with a mental illness who are unable to make decisions about their own treatment at that time. If you have a loved one with a mental health order, you are not alone. There's safeguards, there's independent oversight by the tribunal, and Legal Aid ACT is here to advocate for the vulnerable in our community.